Good morning. It is 8:30 a.m. on July 7, 2026. I am Gregory Chikalian, the hearing examiner with the New Mexico Oil Conservation Division. We have an echo in the room. I wonder whether someone's microphone might be on. All right, we have a docket of 2 cases today. We're going to do the first one first because it is short. It's a hearing by affidavit for Matador Production. It is case 26166. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Adam Rankin appearing on behalf of the applicant, MRC Permian Company, in this matter.
And I don't see any other parties.
Not to my awareness.
Go right ahead.
Thank you, Mr. Examiner. I believe this case was previously presented to the division. The division requested at the end of the hearing that the applicant submit a revised supplemental exhibit packet, including a gun barrel exhibit, which has been done. The exhibit packet was supplemented and refiled with the division, including exhibit D4, which is a gun barrel diagram requested by the division. Having been filed and supplemented, we ask that the case now be taken under advisement, unless Mr. McClure has additional questions for the applicant.
Okay, the amended exhibit packet is admitted into evidence without exception. Mr. McClure, any further questions?
Mr. Hearing Examiner, I will have questions for the geologist and then a really fast question for the landman.
All right, thank you. Who do you have, Mr. Rankin?
Mr. Examiner, let me make sure that our folks are available. I think I saw them online. I believe, yeah, we have our geology witness available.
We'll start with him.
Yep.
I'll swear the land person in at the same time if you find the land person. I think they're both there. All right. Good morning, gentlemen. I can't see your names, so I'm going to have to ask you to spell them in just a moment, but would you please raise your right hands? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you. Let's start with the gentleman in the blue shirt with the pattern on it. Thank you. What is your name, please?
I'm Clay Wooten, ClayWooten.
Thank you. And I recognize that you've been admitted as an expert before this division before, but in what field?
Petroleum landman.
You're the landman. Okay, very good. And you, sir?
Blake Herbert, BlakeHerber.
And have you been previously admitted as an expert before this division?
I have.
Great. In what field?
Geology.
Okay. I think Mr. McClure wants to start with you, Mr. Herbert, so go right ahead.
Thank you, Mr. Hearing Examiner. Mr. Herbert, I'm looking at your, it's just as easy, I guess, just to reference your cross-section that's on page 43 of 49, Exhibit D3.
We're going to share, Mr. McClure.
And that was 43, Mr. Or I guess if you're going off your bookmarks, D3. Mr. Herbert, are you looking at the exhibit with us?
Yes, I am.
Okay, Mr. Herbert, I know we kind of had some discussion about this at the last hearing, but I kind of want to, have it a little cleaner, I guess. Within this cross-section, within the area that is identified between the Wolfcamp top and the Strawn top, you see where I'm referring to?
Yes, sir.
Do you believe that the Cisco or the canyon formations occur within this vertical extent?
I don't know that it does. I would assume there may be some expression of it.
Okay, so would it be accurate to say that you don't have a reason to believe that it doesn't occur? Does that question make sense?
Yes, I think that's correct.
Okay. If it does occur, would it be accurate to say that it would likely occur within your highlighted region towards the bottom of this cross section?
It may. It just depends how thick it is.
Well, I guess let me ask, would your thought process be that it would be below, if it doesn't occur here, would your thought process be that it'd be below this or above this then?
Below.
Okay, so for that to be the case, would it be accurate to say that it would have to be less than 20 foot thick then? Approximately.
Yeah, 20 to 40, somewhere in there. Yes, sir.
Is it Matador's intent to, I guess regardless of where the formation top occurs, is it Matador's intent to produce or complete this highlighted region as a singular unit?
Well, I have a gun barrel included that shows our landing points for these two wells, if that would be helpful, if that's what you mean. And that would be in the upper half of the yellow box.
Does, as far as hydrocarbons that Matador is targeting, is that yellow highlighted area representative of that area?
I don't know if I have anything definitive to say, you know, the stimulated rock volume of these wells. But the landing point is above the midway point in the yellow box. That's where we intend to stay throughout the lateral.
Maybe I don't understand then what the intent was of the yellow highlighted area. I guess what is that supposed to be indicating to the division, this yellow highlighted labeled area, Nina, Cautel, 243H and 244H target?
Right. I highlighted what we consider to be the Wolfcamp D in our regional correlations, making sure to stay above the strong top, just as a general gross formation.
I guess, do you believe there's going to be any barrier to flow of the hydrocarbons within this region?
There may be. There's a clay stone bed in the lower half of the box that we're going to land above. And that may be enough of a stress barrier to where you don't produce down closer to that strong top. But again, I don't know that for sure.
With consideration to Matador's completion plans, do you believe that that barrier is going to be a frac barrier, or would the fracs extend below that barrier?
I think it could be a barrier, but I don't really have any hard evidence to support that.
Are you aware of any other wells within this proposed unit that occurs below the base of the Wolfcamp A?
We have our Nina Cortel 241H on the west side of this section.
Are there any wells that occur within the Wolfcamp within this proposed unit?
If this unit is just on the east half of this section, I think that's, am I saying that right? That this is on the east half only? Then no.
Yeah, I know there's approved APDs in the upper Wolfcamp. Are those wells not drilled, Mr. Gerber?
Oh, I'm sorry. Can you clarify? Did you mean to include the Wolfcamp A in this unit, then there are Wolfcamp A wells, yes.
I mean, actually, my question was excluding the Wolfcamp A, but I guess the route I'm trying, or the thought process is I want to confirm, I guess, that those are the only wells within the Wolfcamp, within the proposed unit.
Yes, with below the Wolfcamp A in the proposed unit, I believe so, yes.
Yeah, there are none, but there are, the only ones within the Wolfcamp are those ones occurring above the Wolfcamp, base of the Wolfcamp A.
Those are above the base of the Wolfcamp A, correct.
And are you aware of any wells within the Pennsylvanian, within this proposed unit?
No.
Thank you, Mr. Gerber. Mr. Hearing Examiner, I don't have any more questions for Mr. Gerber, but I do for Mr. Wooten.
I just have a couple questions for Mr. Herber. I just want to make sure I understood his testimony and maybe to further elucidate a couple points. Mr. Herber, you heard Mr. McClure ask you questions about whether there's any barriers to flow within the targeted zone that you're targeting here in the Wolfcamp D.
Sir.
And you testified that there may be below your landing zone.
Correct. There's a high clay bed there below our landing point that I think could be a stress barrier and a barrier to flow.
And then the target, then if I'm looking at, I'll look at your gun barrel. Okay, so at some point below these two laterals, there is some clay barrier that may inhibit production from below, correct?
Correct.
But as to the portions of the Wolfcamp above your target zones, is that all a single common source of supply?
I think I would say so, yes.
Okay. No further questions, Mr. Hearing Examiner.
Mr. Hearing Examiner, I didn't catch that if you were asking.
Sorry,
me
Mr.
anything.
Sorry, Mr. McClure. Did those questions from Mr. Rankin raise any additional questions, or should we go on to the landman?
Actually, yeah, I'll ask some more questions of Mr. Gerber, if I may.
Okay, yeah, of course, yeah.
Mr. Gerber, Mr. Rankin asked you if the area above this clay barrier whether you would consider that a common source of supply. By common source of supply, how were you considering that?
I guess the source rock reservoir connection between the two. I just don't see really any barriers above our landing point for quite a ways in the Wolfcamp, so that's what I was referring to.
Okay, so I guess let me dig in that a little more. You say you don't see very many barriers or any barriers for ways above your landing point. Can you be more specific in regards to that?
Right, so, sorry, I'm trying to go back to this cross section.
That's fine.
Oh, there we go, that's fine. A lot of times in the Wolfcamp, in the lower Wolfcamp, we'll see thick carbonate beds in the Wolfcamp B and C that we would interpret as a stress barrier to hydrocarbon and to the fracturing. And I don't see those kind of beds in these logs. There's some very thin carbonates in the lower Wolfcamp B and C. But I think this has more of a connection to the Wolfcamp than to the Pennsylvanian below it, would be my opinion.
So I guess towards that end, do you think it would be accurate if, say, the division were to create a pool that extends from the base of the Wolf Camp A to the top of the Strawn, setting aside the clay barrier for a bit, do you believe that the area above that would be accurate if such a pool were to be created?
Sure, yes.
Okay, and where on this cross section does this clay barrier exist?
Again, I'm not sure that it's a barrier, but that the clay bed I'm referring to, if you look at the gun barrel view, just because I'm more zoomed in on the well there, on the Connolly
Mhm.
log. So those are, I believe, 20-foot ticks on here. So 13,260 approximately.
Okay, so Mr. Herber, you believe that there is, or Mr. Gerber, right? Not Herber, is Gerber.
It's Herbert with an H.
Oh, Herbert with an H.
Mhm.
Okay, I apologize, sir. I might have been going back and forth.
That's okay.
Anyway, Mr. Herber, so in regards to this clay barrier, you don't know whether your completion may, or your frac may extend through that?
Right. I don't have any, microseismic data or anything that shows that definitively, but just a bed with that much clay content in it that extends laterally. I think that could be a stress barrier.
And Mr. Herber, you said that you believe that occurs at 13,260. Is that correct again?
On that log, on the Connolly log, yes, sir. It's that bed with the lower resistivity where the cursor is, approximately. Yep. And that's something we can correlate for miles in all directions. So
Say that one more time, Mr. Herber.
that's something that we can laterally correlate for miles in all directions from here.
The clay bed, is that what you're referring to, Mr. Herber?
Yes, sir.
Do you have any reason to believe one way or the other as to where the top of the Cisco or canyon will occur in regards to this clay zone?
No, I haven't seen any biostratigraphy or anything to point to in this setting in the basin for where those age tops would be. This is just what we have called the Wolfcamp D historically.
So then, I guess, do you feel that it'd be more accurate if the division were to create a pool, that perhaps it would, the top of it would be at the base of the Wolfcamp A, and the base of it would be at the stratigraphic equivalent of 13,260 as found in the Connolly Federal 1?
You're saying you would kind of carve out a pool and call that, Wolfcamp something or other.
It isn't the ideal solution.
Yeah.
But I guess back to my question at hand, do you think it would be accurate to say that such a pool would be considered a reservoir or common source?
I think so. Yeah, I think that's a bed there at the base that in this basinal setting does correlate for quite a ways, and it's fairly easy to pick. So it would be a nice marker to go off of.
But would it also be fair to say the top of the strawn occurs below that clay marker, though?
Yes.
Okay, thank you, Mr. Erber. Mr. Hearing Examiner, I don't have any further questions for Mr. Erber.
Mr. Rankin?
Nothing further from me. Thank you very much.
All right. Thank you, Mr. Herbert. Mr. Wooten? I remind you, you're still under oath. Go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Hooton, would it be accurate to say that there are no depth severances that occur within the unit between the top of the wolf camp and the top of the strawn?
From the top of the wolf camp to the top of the strawn. So the wolf camp formation in general, there's no depth differences.
Mr. Hooton, let me re-ask my question. Between the top of the wolf camp and the top of the strawn, regardless as to whether we're considering it a part of the wolf camp, are there any depth severances that occur within that region?
There's a few fee leases that contain a pew clause that would be 100 feet below the base of the wolf camp is how it's defined. But if it's in that wolf camp pool, then I don't believe there would be a depth severance.
Okay, so there are a depth severance that occurs 100 feet below the wolf camp. Is that correct?
For a very small group of leases, yes.
And within that, I guess, how old is this? Was this where this divergence of interest occurred?
It would have been like after the primary term of the lease expired. So probably within the last 3 years or so.
And do we know if those contracts considered this concept of whether the Wolf Camp D is in fact a part of the Wolf Camp or a part of the Pennsylvanian?
I'm not sure on that. I have to get.
Oh, go ahead, Mr. Wooten. I apologize. Go ahead.
I would just have to get with the team to get smarter on the leases specifically.
Yeah, I guess. I mean, you may not know the answer to this, I guess, but if you do you know if the Wolf Camp D is ever actually mentioned anywhere?
It's not, from my knowledge of it, it's not mentioned specifically in the leases.
Mr. Hearing Examiner, I don't think I have any more questions for Mr. Wooten, but in light of this response, if I could ask Mr. Herber some additional questions.
Of course. But first, Mr. Rankin, anything based on the questions to the landman?
I guess maybe just for clarification, Mr. Wooten, I have a couple questions. Thank you, Mr. Hearing Officer.
Sure.
You mentioned, Mr. Wooten, in response to questions from Mr. Examiner McClure, that there potentially are some depth severances that would result from a pew clause in the very few number of fee leases, correct?
Yes.
And those would have taken effect, I think I understood your testimony several years ago at the end of the primary term.
Yes.
But because the leases are being held by production in the Wolf Camp, at least what has been considered to be the Wolf Camp, that those pew clauses have not carved out any acreage or depths out of the fee leases currently, correct?
Yes, from my understanding.
But if the division were to determine that the target interval here is not in the Wolf Camp, then what would the result be?
Just have to get with the team to find exactly where the exact footage of where it is, and then we'd have to evaluate it from there.
But if the division were to determine that the target interval here where the gun barrel shows these wells, if the division were to determine that they were not in the wolf camp, then would that Pew clause take effect and those would be carved out of those fee leases? Is that your understanding?
Yeah, I believe a few of them could. It doesn't, the ones I've looked at are, 100 feet below the base of the wolf camp, so.
Okay. So in other words, the division's decision here could effectively create a depth severance in the middle of what Matador has identified as the wolf camp?
I believe so for a small portion of acreage.
No further questions.
Thank you. Okay, thank you, Mr. Wooten. Can we have Mr. Herbert back? Thank you. I remind you, you're still under oath. Go ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Herbert, I guess if I were to ask you to do an evaluation of the area and try to actually make a determination as to where the top of the Cisco actually occurs, would you understand what I'm asking for?
I would.
Do you have a thought process as to how long such a conducting such research would take?
Well, I've looked into it before, and there's biostratigraphy up on the shelf, so not in this setting where this type of lithology exists. And it's the rock looks very different over there, and it's a bit difficult to correlate where they call top of Pennsylvania down into this setting. The only place I can really say where I can pin the top of the Pennsylvanian would be that strong top that I'm showing. So that may also be the top of the Cisco down here. I could look around a little harder and try to figure some things out. But I'm not sure how long it would take.
I guess, would it be accurate to say that your intent would be to find some wells where you can clearly identify the top of the Cisco and then draw a cross section and correlate it to these wells? Is that correct?
I think that's what would have to be done. Yes. But again, that, the places I've seen where you can definitively call the top of the Cisco based on biostratigraphy are way up on the shelf in a very different setting. I haven't found anything in the basin that's straightforward to correlate.
So, and I guess in that regards, what would be how would you proceed in putting together the cross section and continuing to pick the top of the Cisco as you get closer to this well?
It would be fairly interpretive, but I could try to put something together. I think a simpler method is to have someone call the top in the basin somewhere and then correlate that to here. I just haven't seen where that's occurred.
Thank you, Mr. Erber. Mr. Hearing Examiner, I don't think I have any more questions for the expert witnesses.
Okay, hold on 1 second, Mr. McClure. Mr. Rankin, any follow-up?
No, I don't believe so, Mr. Hearing Examiner. I think we covered the topic enough for the division to make a decision. Thank you.
I have a feeling Mr. McClure is going to want some additional documents. Mr. McClure, go ahead.
Thank you, Mr. Hearing Examiner. Yeah, Mr. Rankin, until we know for sure, I guess, where the deviation here is for the Pennsylvanian, I guess it's difficult for absolute guidance. But I wonder if it is going to occur where we have the Pennsylvanian occurred here, even if that is only 100 foot of it. So maybe it don't even affect the depth severance because of that. I think we may want to cure notice to include the pin, but that would be at Matador's discretion until we actually know for sure if it's even a matter in this case. What's your thoughts on that, Mr. Rankin?
Well, I think because there is no depth severance, all the owners in the mineral estate are the same from top to the bottom and into the straw, and there's no existing or depth severance of any kind. The mineral estate is the same. I don't see the need to publish notice for the pen because the owners would be the same anyway. So I don't see any basis or any need under the regulations or law to do that. Of course, we would do so if we were directed by the division to give supplemental notice. But at this point, I don't see any basis or requirement for doing so.
Yeah, well, the Cisco Canyon is a part of the pen. Does that change any of your thought process there, Mr. Rankin?
No.
Okay, I guess towards that end, we're going to need some additional exhibits from the geologists to try to identify the top of the Cisco or try to confirm that the Cisco Canyon doesn't occur here. What's your thought process as far as timing for that?
Well, Mr. Hearing technical examiner, let me ask if by giving notice that would eliminate the need for additional research or exhibits from the applicant here. If that's what you're saying, that there's an either or, like if we give additional notice that it may include the Pennsylvanian, then would that satisfy the division and allow this case to be taken under advisement?
Well, I guess my concern would be that it sounds like there's a depth severance that occurs 100 feet below the top of the pin. That was your understanding too, Mr. Rankin, is that correct?
Not unless the division that'll only be the case if the division were to create a wolf camp, a base of the wolf camp that would carve out the targeted interval.
Yeah, but what I'm getting at is if we have confirmation as to where the top of the Cisco is, and it's not like regardless, it's not the division like triggering this depth severance. I mean, either the Cisco occurs there or Canyon occurs there or it doesn't. And then there's a matter of where it occurs, and either it does or it doesn't occur there. And if it does occur there, then it sounds to me like that depth severance would come into play. And it would be set at 100 foot below wherever that top is. Is that not your understanding, Mr. Rankin?
Well, I guess the mineral estate would be the same because it's still the same owners, Mr. McClure. It would just eliminate the lease from the working interest. So it would be still the same mineral owners. But again, I think maybe this is getting a little bit overcomplicated, but I think from the applicant's perspective, they would like direction from the division on how to proceed to drill this well or these wells, so they can satisfy the interest owners and their own efforts to produce this acreage. So at this point, I think we would like direction from the division on how best to proceed.
Well, I think what the determining factor here is whether there's going to be a depth severance. I guess that there is where it complicates matters. And so, I mean, the division would, of course, once no waste to be occurred here, so one way or the other, it would be nice for these wells to be drilled, but it's a matter of what the ownership is going to be. And if there's going to be a depth severance there, then it's something we need to know before we force pull anybody. So I guess what I'm getting is, until we get additional facts, I'm not sure what guidance the division could provide here.
So what I'm hearing, Mr. McClure, is that no matter what, you want the applicants to provide updated information on whether or not they can correlate the Cisco and Canyon formations within this portion of the wolf camp.
I mean, I'm not sure how else we can do it unless that lease agreement specifically takes into account the thought processes around Wolfcamp D.
I wonder, Mr. Hearing Examiner, I don't know if it may be prudent for me to take a few moments to discuss with the client whether or not they can even do this. I think my understanding of geologic time is that often you need to have some coring or biostratigraphy to make definitive determinations about what time sequence we're in. And just merely looking at logs may not be, within any scientific certainty, ability to do that. So I'm not sure that we can achieve what the division's asking here with any degree of scientific certainty.
All right, Mr. Rankin, why don't we move on to the next case, and when you have an answer on how you want to proceed, because this is a legal determination that you have to make with your client. I think you understand the reticence that Mr. McClure has at this point. Mr. McClure, you said that under all circumstances, there are documents you still want, no matter what Mr. Rankin comes back with? Or
I
no?
mean, I suppose yes, because of this death severance issue, we're going to have to figure out something on that. Maybe
Okay.
It could be some sort of additional information about those clauses that's in those lease agreements or whatever's going on there, perhaps. That may make the geological side unnecessary. I guess I'm not sure. At this
Okay.
point, we don't have enough information to go off of, really.
Okay. Well, you need more information, it sounds like. And it sounds like you're not sure what information you need. It could be A or it could be B. Why don't we find out from Mr. Rankin after he speaks to his client what he has to say, and then we can decide what information you want. Is that okay?
Yeah, that sounds like a good plan, Mr. Hearing Examiner.
All right. Mr. Rankin is busy. Mr. Rankin, why don't we go into recess on your case? When you are ready, come back. And when I see you sitting there, we'll take a break from the other case because I figure what you have to say will be short. And then we can wrap up your case.
Appreciate it.
Yes, of course. All right, so we're in recess on that first case. Let's now call case number 26060. This is the application of American Energy Resources to reopen division orders R23748 and R22893-A, originally issued under case numbers 25137 and 24837. This hearing is being conducted in hybrid format, in person at Pecos Hall, and via Microsoft Teams, consistent with the pre-hearing order issued on June 18, 2026. Entries of appearance, please.
Jonathan Samaniego, representative of American Energy Resources.
Good morning, Mr. Examiner. Michael Felderwert with Santa Fe Office of Holland and Hart on behalf of Permian Resources Operating, LLC.
All right, thank you both. Let me continue. This proceeding is being recorded and transcribed, so I remind all participants, do not speak over one another or over the hearing examiner. A clean record is essential for a decision. I'm going to start out with a statement of the issues so that we all know why we're here and why we're not here. This is a limited scope hearing, as set forth in the pre-hearing order. And Mr. Samaniego, I believe you received the pre-hearing order?
I did, and I want to make note that it's singling out.
Were you cut off, Mr. Samaniego? Because I just was asking you if you received the pre-hearing order, and I think you said yes to that.
The pre-hearing order was singling out, and I did receive it.
Oh, that's what you meant. Okay, I didn't understand what you meant. Okay, so pursuant to Rule 1915-412 subsection D of the New Mexico Administrative Code, the only issues to be heard today are: 1, whether notice to AER complied with 1915-412 NMAC, in case number 25137 and case number 24837. 2, whether constructive notice was adequate or applicable. And 3, any associated due process or procedural fairness issues. No other issues are before the division today based on the rule that I quoted. This includes, but not limited to, ownership disputes in other cases, challenges to other pooling orders, will proposal requirements, and claims for monetary relief. Those matters are outside the scope of this hearing and will not be taken up. Therefore, no evidence will be taken on those matters. Okay. Before calling any witnesses, I will address procedural compliance. The pre-hearing statement and exhibits. Pre-hearing statements were required to be filed no later than 8:30 a.m. 4 business days prior to the hearing, and to include all exhibits, affidavits, and written testimony intended for use today. Both parties have complied with that pre-hearing order and the rule. All proposed exhibits must be properly filed under 1915-4 NMAC. Exchanged between the parties, sequentially marked and numbered on every page. Failure to comply may result in exclusion of late filed evidence. Evidentiary objections. Objections to exhibits were required to be filed 48 hours before the hearing and will be addressed as a preliminary matter. I didn't receive any objections, so that we don't have to deal with right now. Witness attendance requirements. Any witnesses providing written direct testimony must attend the hearing either in person or via video, and is subject to cross-examination by the opposing party and the division. Witnesses appearing virtually must have a working camera and microphone, or they may be excluded. Order of presentation of cases. The party seeking relief, in this case American Energy Resources, will proceed first. We will follow this order. Opening statement by Mr. Samaniego. Mr. Samaniego, it's optional. If you don't want to make an opening statement, you don't have to. If you do make an opening statement, it will be 5 minutes or less, and it will be timed. Then your presentation of evidence and witnesses, Mr. Samaniego. Then we'll have cross-examination by Permian. We will have questions from the division. Then we will have Permian's presentation of evidence or witness, if any. And I remind you, Mr. Samaniego, Permian doesn't have to put on any evidence if they don't want to. The burden of persuasion is yours. It is not Permian's. Questions by the division, cross-examination by you of any witnesses that Permian presents. Closing statements are optional and will be brief. And of course, if Permian has an opening statement, it's optional, and it will also comply with the 5-minute timeline. Again, testimony must be confined strictly to the 3 issues identified earlier. Mr. Samaniego, do you understand those rules?
I do.
Okay, and do you agree to comply with those rules?
I don't agree with them, but I'll comply.
Mr. Felder, do you understand the rules?
Yes, sir.
And do you agree to comply with them?
As always.
All right. Okay, Mr. Samaniego, do you have any witnesses that you want me to swear in?
I do not. Not at
Okay.
this time.
That's fine. That's fine. Mr. Felder, do you have any witnesses you want me to swear in at this time?
No, sir.
Very good. Mr. Samaniego, this is your opportunity, if you want, to make an opening statement. The opening statement must be related to the 3 issues we are here today to hear.
Not at this time.
Okay. All right. Mr. Samaniego, at this time, we will begin with your case in chief. You may proceed.
Okay. I have just one question. and the question is pretty simple. And my question is to Mr. Felderwert, and it is, did Permian send notice to American Energy Resources?
Mr. Feldwert, Mr. Samaniego, Mr. Feldwert is counsel for Permian, and he's not a witness. He's not been sworn in. He doesn't answer questions like that from you. I understand that you're not a lawyer, so I'm trying to be extremely lenient with your presentation, but the burden of persuasion is on you to show us what I already outlined in those legal issues. So it's your burden to produce evidence. That evidence may be already in the record. You did file a pre-hearing statement. It has a lot of documents with it. Most of the documents are outside the scope of this hearing. However, this is your burden of persuasion, so that question is not appropriate. So would you please move on?
Okay, yes, upon the own evidence that they submitted, Ms. Paula Vance admitted in number, let me find the number she had admitted in, but she admitted that notice was sent to Samaniego, and it was not sent to American on her preliminary statement. Under structured, limited, or LLC laws, an individual and an entity are two separate persons. So any notice that was sent to Samaniego is not proper notice to American, who is the owner. And I'm looking for where I stated that where she made the statement on which number. Give me 1 second.
Mr. Samaniego, do you want a few minutes to collect your evidence to support your statement, and I can return to the first case for a few minutes and then come back to this case?
Yes, sir. Thank you.
Very good. We'll be in recess in case 26060 for about 5 minutes while we recall the first case of the day. I don't have that number. Mr. Rankin, what case number is that?
It is, a moment, sorry, I do have it right here. 26166.
Thank you. So I'm going to recall that case. Mr. Rankin, did you consult with your client?
I did, Mr. Hearing Officer, and I can give you and Mr. McClure the best that we can offer.
Go ahead.
Okay. Mr. McClure, Mr. Hearing Officer, based on Mr. McClure's request and Mr. Herbert's testimony, the best that we can offer is that we can go back and make an effort to correlate these geologic markers across the formation in the proposed spacing unit, with no guarantee that we'll be able to do so with any scientific degree of certainty. In the interim, and as perhaps a belt and suspenders approach, we are willing and suggest that Matador provide additional notice to all parties subject to pooling in this case, that the targeted formation may include the Pennsylvanian. That way, we've covered all potential outcomes by giving notice and also seeking to identify the actual formation tops. And then come back to hearing to present the information that we've been able to identify and confirm whether or not we have any certainty or confidence in the evaluation.
Mr. McClure?
Thank you, Mr. Hearing Examiner. I guess, Mr. Rankin, in your discussion with your client, was there Because we really don't need anything on the lease side unless Matador thinks there might have been reference to Wolfcamp D. At this point, is the assumption that there isn't going to be?
I believe, without conferring directly with Mr. Wooten, I believe that it's unlikely that these legal documents, contemplated how geologists might refer to different intervals within the formation. So I don't think it probably does reference Wolfcamp D.
Now, I'm kind of guessing you're right. That was just kind of a wild card, I guess, thrown out there. Mr. Rankin, the more I'm thinking about this case, I'm almost wondering about bringing Mr. Wooten back and maybe touching base on whether those interest owners that would be how do I want to say this? If there were to be a if it were to be whether there's going to be a different interest owners involved in the area beneath the depth severance and whether they were noticed of this case.
So, Mr. Henning, technical examiner, in that instance, if there were a depth severance that occurred through the PU clauses, then a portion of the lease would have essentially been carved out, and then that interest would have reverted to the underlying mineral interest owner, and not the lessee. So in that instance, potentially those mineral interest owners would not have been noticed of this pooling. So if it's the division's pleasure, we could potentially go back and determine who those mineral interest owners are and potentially try to give them notice. But at this point, our preference, I think, would be just to give notice to the pooled parties.
Yeah, I suppose at this point, I'm just thinking about maximum routes that we have towards a conclusion here, I guess. And I'm almost wondering if that could be of assistance, but not necessary. And just thinking about timing this, because I don't know when Matador wants to put this on their schedule, I guess.
Very soon, Mr. Technical Examiner, I believe, if I'm not mistaken, the rig may actually be there. So, because in this case, they're pooling a very small interest. It's like it's 1% approximately interest that's being pooled.
I guess at your discretion, I guess maybe there's consideration to providing those individuals notice, but at this time the division wouldn't be requiring it.
When you say those individuals, who do you mean? You mean
the mineral interest owners?
Okay.
That the interest would be reverting to.
Okay.
I mean, essentially, Mr. Rankin, to give you some context, I'm just thinking along the eventuality that we're not going to have a scientific determination of where this topic occurs. So hypothetically, in that instance, maybe there's some sort of thought process to, at least they provided notice here, but I don't know what the division's position is going to be. I'm just trying to think of having all available thoughts in as fast of a time as possible, I guess, taken care of.
Mm-hmm. Well, Mr. McClure, I guess as I stated, we suggest and recommend that in the interim, while we're evaluating the ability to correlate the geology across this zone, that we go ahead and give notice to all parties subject to the pooling that the targeted interval or pooling might include a portion of the Pennsylvania formation.
So then based upon what you're saying there, then you would go ahead and notice the mineral interest owners, even though it may not be required at this point.
Well, I'm just saying,
I mean.
Yeah, the current, in other words, assuming that the PU clause did not take effect, okay, yeah.
Okay, then the only thought process, and this is purely a matter of discretion, would be if you just wanted to notice the people in case the pool clause does take effect, I guess.
Okay, I'll confer with the client about whether they want to do that and then proceed from there. But in the interim, we'll go ahead and give notice, at least as to the current owners.
Sounds good.
Mr. Rankin, is that all?
Mr. Hearing Examiner, Mr. Technical Examiner, are there any other requests? The only other issue is timing, and if it's okay with you, I'll follow up with the division today, since there are no other parties, and let you know what our expected timeframe would be, and then ask for that docket based on the ability to put this together.
And we'll give it priority, Mr. Rankin.
I appreciate it.
I understand that you have a rig out there, and we don't want to hold you up if we don't have to.
Appreciate
So
it.
Freya, when Mr. Rankin communicates with you and Mr. McClure, would you make sure I'm part of all that so we can determine the most expedient docket to put this case on?
Yes.
Thank you. Mr. McClure, anything further?
Nothing from me, Mr. Hearing Examiner.
Mr. Rankin, anything further?
Nothing further, thank you.
Okay, we're off the record in your case. Thank you. Let's return to case 26060. Mr. Samaniego, are you ready to proceed?
Yes, Mr. Examiner.
Go right ahead.
Okay, yes. On Permian's pre-hearing statement, right after the statement of the case, it talks about cases 25137 and cases 24837. And it says pulling order R23748 was issued under case 25137 on April 1st, 25, at the request of Permian. The division record for this case establishes notice of the pulling proceeding was directed by certified mail to Jonathan Samaniego at 511 Lavelle and P.O. Box 114 in Hagerman, addressed to Jonathan Samaniego. Filing exhibits 25137, notice to Jonathan Samaniego, was also provided by publication in the Carlsbad-Kern Argus weekly newspaper of general circulation in the county. And then it goes on, the filed evidence establishes that case 25137 Permian comply with notice obligations and provided constructive notice of the proceedings to Jonathan Samaniego, the principal owner and agent of American. And then it goes on to case 24837, order 22893A was issued under case 24837. And on this one was SPC, but Permian purchased SPC and amended the case, but originally it was SPC that was purchased by Permian. The division record from the original pulling establishes that notice of pulling proceedings was sent to SPC by certified mail to Jennifer Roper, and she was the one I bought the house from, a predecessor to the title of Samaniego. And I didn't have time to get the deed for that property, but that property was purchased through my real estate company, Black Gold. The property I bought from Jennifer Roper never went into Jonathan's name. That was always in my real estate company's name.
Mr. Samaniego, hold on one second. I understand where you're going with this, and it's fine. The problem is you've not been sworn in. So you're not a witness in this case. And if you want to introduce evidence, and you're more than welcome to, you do need to be sworn in. Otherwise, these things that you're saying.
I understand. I don't have the paper. It's irrelevant. I get it.
No, I didn't, Mr. Samaniego.
Okay, so
Can I finish my sentence?
Yes, sir.
I didn't say it was irrelevant. I never said that. What I said is you're trying to introduce evidence about the ownership and the address, and that's fine. You're more than welcome to do that, but it has to be done properly. And the only way to do that is to get you sworn in, and you'd have to turn on your camera to do that. Are you willing to do that?
I don't have a computer that has those things.
All right. Well, in the pre-hearing order, it was very specific, so I'm just being very clear with you. If you wanted to introduce evidence, it had to be through either sworn testimony or documents submitted with the pre-hearing statement. You did provide a pre-hearing statement. I have it in front of me on June 15th. It's 145 pages, so I do have that, and that's fair. That's fair game in this case, as long as it's relevant. But if you're trying to introduce new evidence about the ownership of the house and the address and the name and all of that, you'd have to be sworn in. And that, I think, was very clear in the pre-hearing order. And if you don't have the ability to turn on a camera and be sworn in, what you're saying now is great, but it's not evidence.
Yes, sir. Then I'll just make it quick and simple.
I'm not telling you
notice
how to present.
the permit.
Hold on, Mr. Samiengo. I'm not telling you how to present your case. You don't have to make it quick and simple if you don't want to. I'm just explaining to you that if you want to introduce evidence, there's a way to do it. And so far, I can't, so far you haven't done that. But anyway, please proceed with your case. I'm not telling you how to proceed.
Yes, sir. I'm just trying to proceed with caution because I'm in fear of making you mad. Like I'm trying to walk on eggshells. Like I'm trying to be very careful.
Please proceed, Mr. Samiengo.
Okay. On the pre-hearing statement of Permian. They're saying that Permian sent notice to Samaniego, to Lavelle, and the P.O. Box address to Samaniego. And then they did publication listing Samaniego, but yet in their preliminary statement, they're admitting that Samaniego is an owner of American. But yet they didn't send notice to American, yet the constructive notice wasn't to American, but yet they're admitting that Samaniego was principal owner of American. And they sending notice to Samaniego is not proper notice, regardless of who the principal owner is, because under structured LLC laws, American is its own entity. And is required, proper notice is required being sent to American, the entity, not any member or affiliate or agent, or it should be sent in proper notice to American. And because proper notice was not sent in either of the cases by their own admittance, their objections should be moot.
Okay. Okay. Do you have anything else to say at this time?
No, sir.
Okay. So here's what I understand so far. You are relying on the statements of the party opponent, which is Permian in this case, to substantiate that notice was not correct. So the rule 1915 412D says evidence of failure to provide notice, as this rule requires, and other parts of this rule requires, may upon proper showing be considered cause for reopening the case. Okay, so in doing that, you have basically relied on statements of a party opponent. You've relied on their pre-hearing statement. You've relied on documents that are in the administrative record already, and that's fair game. So I'm not saying that you've proved your case. I'm saying what you've done so far. Do you have? I also laid out in my order granting and denying Permian Resource operating motion to dismiss. Did you, that order was issued, let me get you the date on that. I issued that order on May 26th and sent you a copy. Do you have a copy of that?
I'd have to look. I'm not sure.
Okay. In that order, I basically laid out what the possible genuine issues of material fact are, or the way I saw them, based on the motion, the response. I laid out what I thought the issues in contention and the material facts in contention and why we needed to have today's hearing. And that's why I did not dismiss 2 of your 6 cases. You could have used that. You could have used that as a structure to present your case today, but you presented your case. Do you have anything further before I turn this over to Mr. Feldewert to present his case, if he so chooses?
Yes, everything you said, I admit into my case and my evidence.
Okay. All right, Mr. Samaniego, do you rest your case in chief?
Could you please repeat?
Sure. Do you rest your case in chief?
I'm unfamiliar with what that means.
Oh, okay. Have you presented all the evidence that you are prepared to present in your case?
I think under the order, I was limited on what I can file. So I think I am, but I'd like to hold the right to be able to bring forth any other claim.
Let me discuss that with you for a moment. I will allow you to present a rebuttal case if Mr. Feldewert produces evidence that in some way you could not have prepared for. So I will allow you to do that. We allow that to every party, Mr. Samaniego, but I'm not going to allow you to bring other claims. The claims that you are allowed to discuss today and supply evidence are the issues that I outlined in the pre-hearing order. They are, again, whether notice to AER Samaniego complied with the rules in those 2 cases, whether constructive notice was adequate or applicable, and whether any associated due process or procedural fairness issues exist. So, and I read that out before you presented your case. So I just want to be clear, those are the issues that are in contention today. So if there's no further evidence from you, I'm going to turn now to Mr. Feldewert to see if he wants to make an opening statement.
On the motion for the reopen of the dismissed cases, you're saying that they hadn't been dismissed. Could I move forward with the motion to reopen the dismissed cases since they weren't dismissed, but with the evidence in the filing?
No, I was very clear in my order granting and denying Permian's motion to dismiss your cases that we needed to have an evidentiary hearing in these 2 cases, 25137, 24837, because there were potential issues of material fact. In the other 4 cases, there were no issues of material fact. Now, if you have an ownership dispute with Permian, this is not the forum to bring it. That would be the district court, wherever that district court may lie, and I'm not here to give advice on how to do that. But this forum does not resolve issues of ownership. It does not do that. We take people at their word. I did research before I issued this order granting and denying in part, and that's over. So no, there's no motions to reopen the 4 dismissed cases. Was there anything else before we turn to Mr. Feldewert?
I just want on the record that American filed 3, 4, 5 motions since last hearing, and they were not addressed at last hearing, and then they were singled out by the order for this hearing. and then now you're saying to go to district court about it.
Mr. Samaniego,
That's singling out.
okay, Mr. Samaniego, let me remind you of something. If you're not happy with the decision of the division at the end, when we issue a final order on your case, you can appeal it to the commission. Okay, I'm not hearing anything further.
Okay.
Mr. Felderwart, do you want to make an opening statement?
More in terms of observations, okay? So first off, on July 3rd.
Of what year?
The Friday.
Okay.
At 6 p.m., okay,
This year. Okay.
is when Mr. Samaniego filed his pre-hearing statement under your pre-hearing order. On July 3rd, it's around 6 o'clock. And I think that's what he's referencing periodically throughout his statement. Now, I think you would agree, and you perhaps may have already observed, that that is clearly untimely under your pre-hearing order. And you referred back to a June 15th preliminary statement, which I did not view as being responsive to your issues that you laid out in your pre-hearing order. So I took a look at the July 3rd filing, which of course was a holiday, and only one business day before this hearing, and certainly less than 48 hours prior to the ability to file any objection. But I think when you look at that, there's nothing in there, very little in there, if anything, that I saw that was potentially relevant to the issues, okay? What has become clear is that he seems to take the position that that he's not disputing that notice or constructive notice was sent to Jonathan Samaniego, or in a case of a property dispute, to his heirs, okay? He is suggesting that Permian should have sent notice of these applications to American Energy. Important to that, then, is the date that those applications were filed, okay? The pooling application, that's the subject of case 21537, which I'm going to call the just for simplicity, the Bone Spring Spacing Unit, okay? That was filed in January of 2025, and the pooling order issued in April of 2025. So that's over a year ago, okay? The second case at issue here, which I'll reference as the Wolf Camp Spacing Unit, was an extension, sought an extension of the drilling deadline. That was filed by Permian in September of 2024, and the order issued in November of 2024, almost 2 years ago. So if we keep those dates in mind, I looked at what he filed, and I didn't see anything to indicate that American Energy was a record title, or was an owner of any of the properties subject to those two cases at the time that the application was filed. Okay, so that's number one. Number two, we also know that Mr. Samaniego is the agent and principal owner of American Energy. In fact, if you look at their filings, they use the same P.O. box. So when Permian sent the information to Samaniego, Mr. Samaniego, who is now the agent of American Energy, but who was either the owner or the purported owner or someone in a dispute over the title to the property at issue. It was properly done by Permian because he was the owner, and it was constructive notice, not only to himself, but to any company that he had at that time and any company that he subsequently created, okay? So in light of that, I'm not sure there's anything else to address.
Okay. Okay. So Mr. Samaniego, Mr. Felderwart has not felt it necessary to put on a case. He's not calling witnesses for you to cross-examine. So we really are relying on the documents that the division has in its possession, either from the original cases when they were filed back in January of 2025, or for the extension case, September of 2024. All those documents are in our records, and I take administrative notice of all of that evidence. So there's a substantial amount of evidence that was supplied by Permian at the time it applied to the division for the Bone Spring case and for the Wolfcamp extension case. That evidence may or may not support your argument, Mr. Samaniego, but it is in evidence. So I'm letting you know we do have evidence in the case, even if you did not supply it by the due date that I set out in my pre-hearing order. Mr. Samaniego, I do have a question for you, and I really bent over backward to help you in this case present your case. I'm not helping you win your case, but I am helping you present your case, and I hope you understand that. I am taking your preliminary statement that you made on June 15, or that you submitted on June 15, and all 145 pages as your pre-hearing statement. Do you understand that?
Well, also on the pre-hearing statement, I also made record about the letter that was in transit. It was never delivered. The letter was in perpetual transit and never delivered. They brought no evidence of any letter being delivered. To my knowledge, this letter being delivered to Samaniego is still in delivery at this very moment.
Yes, I understand that, and that was one of the reasons. Mr. Samaniego, hold on a second. You didn't answer my question, though. I want you to acknowledge the fact that I'm bending over backward to help you present your case today. In doing that, I have accepted your preliminary statement, 145 pages long, to act as your pre-hearing statement. Even though Mr. Folderwort doesn't consider it a pre-hearing statement because you did not comply with the pre-hearing order. So do you understand that I've done that?
No, sir.
Okay, you don't understand it. That's fine. So, Mr. Samaniego, when I issued
I'm saying that you didn't help me to the fullest of your ability. You're allowing him to attempt to dismiss another case without proper evidence, just like the past 4 cases that were dismissed without proper evidence, and now I got to take it to district court.
I don't know where you're getting any of that. I didn't say any of that.
The record for the pre-hearing statement was that Permian did not provide notice. Their letter, Permian's exhibits, 958, 907, 105, 2700, 5811, 56851, addressed to Samaniego, was never sent. It was never sent to Samaniego. It was never delivered. And by the own evidence Permian presented, it's still in transit. In transit. No, not delivered. It says in transit by their own evidence presented.
Mm-hmm. Yes, and you said that, and I've heard you. So I'm going back to the pre-hearing order. I'm going back. Mr. Samaniego, please, would you mute him, please? Mr. Samaniego, I had to mute you because you're doing what you said you weren't going to do, which is to talk over either the hearing examiner or the other counsel, because we are trying to have a clear record in this case. I issued a pre-hearing order weeks ago. It outlined when you needed to issue your pre-hearing statement. You decided not to comply with that, as was brought to my attention by Mr. Felderwort. You didn't get your pre-hearing statement in until July 3rd. That's not timely. So that doesn't count as a pre-hearing statement. But I've bent over backward for you, Mrs. Samaniego, in admitting the preliminary statement, because you're not a lawyer, to act as your pre-hearing statement.
I asked for a conclusion.
I can't understand.
And I filed the pre-hearing statement at the proper time.
I can't understand you. Would you say that
I filed
again?
the pre-hearing statement.
Mr. Samaniego,
I
I can't
filed the
understand
pre-hearing
you.
statement.
Go ahead. Mr. Samaniego, what did you say?
Can you hear me?
Yes, go ahead.
Hello? Yes, sir. The pre-hearing statement was filed in the appropriate time, regardless of the time I filed it. It was still filed 4 days prior to the hearing. It's still within adequate time, regardless of it being at 6 o'clock rather than 5 o'clock. It's still 4 days prior to hearing. To move forward with those statements is improper. It's contorting the whole process.
Okay. Thank you for that. Unfortunately, the proper timing of the pre-hearing statement would have been, I think, Wednesday of last week because, Mr. Samaniego, there was a holiday, and 4 business days before today is about Wednesday of last week. But nevertheless, I have accepted your preliminary statement, which you seem to refuse to acknowledge. I don't have to do that, but I'm doing it for you. So you do have a pre-hearing statement in this case. Okay, so now with the evidence that we have, I have to make...
Keep the record open so that I can submit evidence.
I'm sorry.
If you could just keep the record open.
This was your opportunity to submit evidence. I don't understand what you're asking.
To keep the evidence open so I can show the Jennifer Roper deed to show that deed was never in my name. That was in my real estate company's name. That property was never in my name for them to be saying they sent it to Samaniego. That's a flat out lie.
Okay, Mr. Samaniego, I understand that you disagree with that statement, but and that's not even evidence in this case. Can I finish? Mr. Samaniego, can I finish?
Hold on, I got court
please?
here at 1.
Would you mute him, please? This is sort of devolving into a shouting match, and that's not going to happen in this forum. So there is no evidence in the record regarding the previous owner of the home because you did not properly submit the evidence. And I'm not going to leave the record open because...
You didn't give me the time. I filed for...
What did you say? Mr. Samaniego, if you appear by phone like this, it makes it hard to hear you, especially if you talk over me. What did you say?
I'm saying that I filed 2 continuances so that I would have adequate time to do my filings in this case. I'm backed up with another case out of Texas, and what I'm trying to do here, by denying my continuances, it bottlenecked all my attempt to give proper attendance to this case by bottlenecking it up at the holidays so that erroneous acts could take place.
So, Mr. Samaniego,
that's why I filed the continuance.
Mr. Samaniego, let me speak. What motion are you talking about to continue the case? I didn't receive a motion.
Yes, sir. I filed 2 continuances or 2 motions to continuances. And the last one I filed, Freya said that it was she piggybacked it on the hearing from the last hearing, scheduling this hearing, and she piggybacked my motion for continuance for this hearing. But I filed 2 motions for continuances. It should have been continued the next month so that I had adequate time.
Mr. Samaniego, first
of all, you guys bottleneck me with cases.
Will you mute him, please, again? Mr. Samaniego, you have to stop talking when I start talking. If you don't do that, I'm going to have to continually mute you, and you're not going to be able to speak, and that's not in your best interest. So why don't you wait and let me look at the case file to try to understand what you are talking about. So I'm opening up case 26060, and I'm looking for a motion to continue. Now, Mr. Samaniego, what date did you file the motion to continue?
Hello?
I don't. What date did you file the motion to continue?
Yes, sir. I'm getting it right now. I'm looking through the case filings right now to get it. Yes, sir. The first one, I believe, was filed June 26th. And then the other one.
Okay, so Mr. Semiengo, let's deal with these one at a time, okay? I'm looking at the document you're talking about. It's a 3-page document, is that correct?
So let me go back to that one. Let me see. One, two, yes, sir.
Okay, so Mr. Semiengo, here's what your document says. It says unopposed motion for continuance. Jonathan Semiengo hereby files an unopposed motion for continuance in case 26060 on behalf of AER in the above referenced case. Okay, now, first of all, your motion was opposed, okay? Ms. Vance did oppose your motion for a continuance, so this document is not correct in its title. But second of all, you don't tell me why you want a continuance here. You don't supply any evidence of why you need a continuance. So that is standard practice. When you file a motion, you have to file some evidence with it to explain why you want the case to be continued, why there's some sort of hardship to you, and you have to title it properly. This should have said opposed motion for continuance. In a motion that you file with any forum, including a court, if you don't properly state the opposing party's position, it's bad form, to say the least. So do you understand why this wasn't granted?
No, sir, because in the statement for the motion for continuance, Paula Vance made false statements that she was only given 2 minutes on the response, when I think she was given just shy of 20 minutes.
Okay.
So she had ample time to respond. I can't just hold up and wait for her to respond.
Mr. Semiengo, but she still opposed it. It's still opposed. It's not unopposed. Just because you didn't agree with the time frame, she made it clear that she opposed this motion. And we knew that she opposed the motion.
And at the last, right after the fact, I know, after the fact. But at the last hearing, I made it clear statements that Jesse Tremaine is aware why I have hearings, and I made clear that I have schedules on the 7th with those other hearings, and you still move forward in scheduling this hearing for today's hearing, knowing I had pre-hearings, other schedules I had to abide by. And I don't know if you asked Jesse Tremaine, but Jesse Tremaine is very aware why I got courts. And I made that clear at last hearing. That's why I filed the motion for continuance. And that's on the record last hearing when I said that I had
Mr. Semiengo, stop speaking. I'm reviewing the verbatim transcript from June 22nd. We have that, by the way. And I'm seeing where I called the case, and I'm looking for where you tell me that you're not going to be ready on today. So give me a minute. I'm going to keep looking. This was the case in which we started at 8:30. This was a status conference, and you said that you were not ready at 8:30. You thought that we started at 9 o'clock. So let me review the transcript. Okay, so Mr. Semiengo, you confirmed on June 22nd that you would be ready today. It's in the verbatim transcript. If you're more than welcome to look at page 17 and page 18 of that transcript. This unopposed motion for a continuance, number one, was incorrectly titled. It did not explain why you needed a continuance. It did not ask for an alternative date, and it provided no evidence to support why you wanted a continuance. Therefore, it was not ruled on. Okay? So I'm not leaving the record open for any further evidence from you. You had today to provide it, and you didn't provide it. Now I'm going to go over what I needed to hear from you and why I didn't hear that. So we're dealing with proper notice, okay? And your burden of production in this case was to show that evidence that you did not receive proper notice. And I left that open to you to do that. The first thing you were supposed to show was that Permian knew or should have known the correct address. That's number one. Number two, that AER was the record or known owner at the time. Then you were supposed to show me that certified mail was not delivered, and I did understand that you said that one of the certified mails was still in transit, and I do understand that. Number four,
all of them, not one, all of them.
I don't know that I know that, Mr. Samaniego. All of them?
It's all with the evidence that Permian presented, and I've presented to you. What do you mean you don't know? I presented this to you.
I understand that in one case, notice said that it was still in transit. What do you mean all of them?
Because that's the only case they admitted to sending notice in. All the other dismissed cases, they admitted to not sending notice. This is the only one that they're admitting to sending notice to, and it's compromised. It's still in transit today.
Okay, and I've already acknowledged that I understand that. Then you were supposed to show me that that AER was locatable, so that constructive notice was improper. And finally, you needed to show me some material prejudice to your due process rights. I don't find that you've met that burden, Mr. Samaniego, so I am going to dismiss your other two cases based on the evidence you provided today. And again, you can appeal that decision to the commission, that you can have a de novo hearing, and you can do the whole thing over again. Do you understand your rights?
I want to ask if the examiner can keep the record open to submit the deed to show that Permian is lying, even though it's not. It doesn't change the fact that they didn't give proper notice because it's still in transit. But at least it would kind of give a pattern of their continuous lies.
Okay, Mr. Felder.
Also, American filed the motion.
Okay, hold on, Mr. Samaniego. We have to handle one thing at a time. I'm asking for Mr. Felderwert's position on that motion to keep the record open.
Mr. Examiner, I think when you look at the history since this matter was filed back in March, that you've bent over backwards to give Mr. Samaniego and American Energy the opportunity to present their case. They've placed multiple filings, multiple documents into this record. So I see no reason to allow the evidence, allow the case to remain open.
Mr. Samaniego, the motion to reopen the record is denied. The record is closed. Did you have something else to say?
Yes, that I filed a motion to motion to disqualify the hearing examiner for lack of impartiality, and this is my second motion filing for this because there was no just right to dismiss the four cases. As today, there's no just right under their mailing still being in transit perpetually to dismiss and deny Americans reopening of these two cases today.
I understand how you feel.
And again, this is another third. I'm not done. This is now the third attempt in this exact same hearing where the hearing examiner has showed lack of impartiality and bias toward American by continually finding abilities for Permian to weasel out.
I find Mr. Samaniego, can you mute him, please? I'm going to speak, Mr. Samaniego. I find it amazing that after all of what I've done to get your case here to a hearing and give you a fair and complete opportunity to present your evidence to the tribunal, that you can still say that on the record. So I'm going to conclude today's matter at this point and not give you any further opportunity. You can file an appeal with the commission once the final order is issued. This matter is closed. Thank you.